Good evening, this is John Milburn, Laws 12067, Environmental Law. This is week 10, and this week we deal with criminal law, but in a broader context. The prescribed reading is chapters 18 and 19 of the text, problems 22 and 23 are relevant, and what we want to talk about tonight is the criminal law in the broader sense in terms of a prosecutorial nature and a defence nature. So for those of you that have already submitted your assessment, thank you for doing so. I really appreciate that. And more than half the class have already presented their assessment. So if you wish to join me live in terms of asking a question, please feel free to unmute your microphone or use the chat facility. In terms of the assessment piece, I hope to have the answers back on Sunday of next week. So with all of my assessment, it's due on a Thursday evening, and the final cut-off, whether you've received an extension or not, is the following Saturday. So you've got effectively 9 days after the due date to submit your work at the penalty of 5% per day of late submission. My aim then is to ensure that I've marked all of the assessment so that I can release the results on the Sunday or the Monday after the due date. That is the day after or the day after that. Okay, so criminal law. Firstly, in Moodle, I provided you with a link to a video that I did some time ago in relation to the first appearance in a criminal law matter generally. I'd refer that video to you. I've corrected a mistake in terms of the link, so you should be able to access it now if you were having problems in doing so previously. But when it comes to criminal law, bear in mind that in an environmental context, it is really only one area of enforcement generally. So for regulators, as you'll see in chapter 18 of your text, there are many other ways that they can go about enforcing environmental litigation. So administrative remedies, civil remedies are very effective. And in some argue, civil remedies are more effective than criminal sanctions because, well, it's easier to prove. It's a balance of probabilities rather than beyond reasonable doubt. And a very great disincentive is the issue associated with costs. And normally the legal costs can far outweigh the potential fine that might be imposed by way of criminal sanction. And then, of course, there are issues to do with representative litigation and suing a company or suing an individual. So civil remedies and administrative executive remedies can also provide some opportunities for litigation and enforcement. However, in terms of the criminal sphere, I guess there are a number of questions that you need to ask from a prosecutorial perspective. One is, what is the legislation under which you can bring your action, your prosecution? And there's a wide range of different pieces of legislation, some Commonwealth, some state. I guess the next thing is, who are you issuing the proceedings against? Do you have enough evidence to litigate against an individual, corporate member of a company that is acting, you might allege, criminally in its environmental damage? So that's another factor. Then there's an issue of what court the matter is dealt with. It may be that the matter is dealt with entirely summarily. Summarily meaning in the magistrate's court, or it may be that it's dealt with summarily in the context of a committal, and then following a committal dealt with by way of indictment in the superior courts, in a state jurisdiction, the district court or the Supreme Court. And the committal, of course, is the process by which a magistrate determines whether there is sufficient evidence to warrant the matter proceeding to the higher court. And the test for a magistrate is simply this: whether a jury, a reasonable jury, can, properly directed, could possibly come to a verdict of guilty. And that's a pretty easy test to overcome from a prosecutorial perspective. Then, of course, when you're thinking in terms of criminal law proceedings, you've got to ask yourself questions like, is there an intent element in the charge that will need to be established before a prosecution can be successful? So it may be that the particular charge requires prosecution to prove beyond reasonable doubt that the intention was there and the act was conducted or undertaken in the full knowledge and with the intent of committing a crime. So you'll see some commentary in relation to that in Bates. And sometimes it may be that the prosecutor can be successful in establishing criminality without necessarily the specific intent to do this particular harm, but by establishing a recklessness in circumstances where it would have been probable or possible that the act would have occurred as a result. To use the wording in the text, recklessness denotes the accused acted in the knowledge that a particular consequence was probable or possible from the conduct. Unlike intention, where the actus reus is the purpose of the accused's conduct, in recklessness, the accused need not have the actus reus for the purpose of the conduct. So willful blindness. You can imagine a person causing substantial injury by walking into a crowded room, darkened room, and swinging a machete around. It would be inappropriate and impossible for that person to say, well, I'm not guilty because I didn't intend to harm that particular person. The recklessness of the behaviour is sufficient to establish a criminal liability in those circumstances. All right, so some of the issues.
Oh, I just got a question, John. So does recklessness, will that always get up?
Oh, no, not always. No, not always. In some instances, the court will find that there must be the required intent, which is not sufficient in those circumstances. So, for example, murder, for example, requires a specific intent. A charge of grievous bodily harm requires an intent as well. That is, if the charge is grievous bodily harm with intent to cause grievous bodily harm. So sometimes the requirement for intent is specific, and in those circumstances, recklessness may not be sufficient. So I won't always get up.
Yeah, so it's a case-by-case situation.
Exactly. Yep. Thank you, Tony, for highlighting that. Have a look at the commentary in relation to the vicarious liability of directors and managers. That's 18.63. Now, what I've done is talk about the prosecutorial aspects, and there's also the defence aspects. Oh, I should point this out. Have a look at the specific legislation that is relevant to the particular case. So, for example, under the Environmental Protection Act 1994 at a state level, have a look at section 437, and that provides that a person must not willfully and unlawfully cause serious environmental harm. Section 437 subsection 2 provides that a person must not unlawfully cause serious environmental harm. So the first one, coming back to your point, Tony, is the prosecutor must establish willful and unlawful, as opposed to subsection 2, which provides that the defendant must not unlawfully cause serious environmental harm. So an act is unlawful in those contexts if it causes serious or material environmental harm. However, we get on now to defences. It is a defence in that context to prove that the harm occurred even though the defendant was complying with his or her general environmental duty, that is, by complying with the relevant code of practice or in some other way. Have a look also at section 24 of the EPA. That provides that the Act does not limit on any civil right or remedy that exists apart from the Act. Therefore, the imposition of a penalty for criminal sanction does not preclude a person from pursuing civil remedy for damages. So it may be that there are the two avenues that can be pursued in those circumstances. All right, now Bates outlines a number of defences. Due diligence, which is a little similar to what I was talking there about in the environmental protection case, where there is the environmental duty. Have a look at the defence of honest and reasonable mistake of fact, which is section 24 of the Criminal Code. and that will apply in environmental litigation. So there's some good commentary there. And then there's some corporate defences as well. So when it comes to considering defences, as a defence lawyer, you need to consider whether there is any specific defence available to you under the terms of the statute by which your client has been prosecuted. But in addition to that, also consider the more general defences that are available to a defendant in the criminal code. And in a Queensland context, I think that starts at section 22 through to about section 32. So have a look at those sections as well. So you need to be, and then of course you need to consider from a defence perspective whether your client as an individual can be deemed or found to be liable from a criminal perspective for the actions of a company. It may be that your client is a director, for example, and there may be that issue of vicarious liability, maybe even strict liability that you need to consider. Okay, now apart from the issue of defences and prosecution, you need to consider which court the matter is dealt with, and we touched on that briefly. And that can vary depending on the nature of the legislation that you're dealing with. So, for example, under the, let's see if I've got some notes here, under the Environmental Protection Act, it does provide that certain matters must be dealt with in the magistrates' court summarily, and others must be dealt with by way of indictment. So I'm looking to see, have a look at section 16 and 17 of the Environmental Protection Act, and that provides some guidance in relation to the different types of matters. In terms of the dichotomy between indictable and summary, have a look at the specific acts. For example, the Vegetation Management Act provides that matters involving it must be dealt with summarily. The Environmental Protection Act deals with the issue by saying that an offence which carries a maximum penalty of 2 years or more is indictable, and then it breaks down between a crime as an indictable and a misdemeanour. But it basically says everything else is a summary offence. Okay, now it is possible under the criminal code. I've just received a message from, is anyone having problems in seeing me there?